after my lord, I had argued whatever, it's not very relevant, but just to tell your lordship. The additional advocate general also argued, and his submissions are also recorded. And during the course of his submissions, he handed over, my lord, a memo to the court. In the southern states, at least, they call it a memo. A memo was handed over containing 3-4 documents, which included, my lord, 14th May and 5th June of 2018. He handed it over.
If I may,
1 minute, please don't. I am sorry, please. This is not fair. He handed over a memo containing these documents, and he made submissions thereon. And after him was the rejoinder of the other side. So the documents were handed over to the learned judge, submissions were made, and this was in the presence of the petitioners who gave a rejoinder after the AAG. But be that as it may, it was reserved on 19th. On 20th, my lord, the same memo which was handed over to the court was formally filed in the registry because the judgment had been reserved. So the memo was twice over. Once in court, my lord, and not knowing whether it may remain in court, it may get lost in the bundles, or he filed it, my lord, in the registry also. That is the sequence, my lord, of this memo. Whether this should have been done, shouldn't be done, the practice which has gone on. Original practice was that you better file everything in the registry. You can't give it like this, etc. But my lord, that's really what happened. Now they also filed, my lord, on the date of hearing, a bundle of 400 pages in the court before the judge. We also filed a counter, my lord, on that day, etc. All that, my lord, went on, but there was anxiety on the other side, so it was heard on day one. Otherwise, my lord, with all these,
Mr. Salve's grievance is not that they were not heard on this.
No, I am saying, my lord,
and therefore, at the outset, we said
that's okay.
And he said, there's no point in.
So I am saying, my lord, they filed documents, huge bundle on that day. He filed this document, and the AG argued on the documents. They also argued in their documents. That's how it went on. Nobody made a grievance on that day. Why are you give us time? It just went on that way.
Or have I made it yesterday?
That's fair enough. That's how it went on. I'm only giving a factual thing. And because at the AG, the additional advocate general relied on it, the learned judge, my lord, has relied on it. Right or wrong, he has relied on it at 2-3 places, which I want to show, and then I go back to my facts. Kindly turn to the judgment under appeal. Kindly first turn to page 21. And there is a copious reference. It's not, my lord, a one-line reference. Page 21 at the foot, my lord. When we are talking about, my lord, events which were prior to 2018, 21 paragraph 9. On the other hand, the AG, Reddy, submits that with regard to allegations of corruption against the officials of this corporation, the DGACB vide a memorandum dated 5th of June directed to consider a regular inquiry into the letter petition. That letter petition, my lord, is 14th May 2018. Your lordship, when out of the side, I'll show that, your lord. Is 14th May, which came from Pune, and submit a regular inquiry report by referring to a letter of CBI dated so and so. So, my lord, that fellow wrote to the CBI also. It came to us also, and CBI sent it to us. That's why these 2-3 dates. According to the AG, inquiry had commenced much prior to the insertion of 17A. According to him, such circumstances, there is no bar on the police to conduct investigation. According to him, any statute that has been incorporated will be prospective, which means, my lord, that earlier allegations will be governed by the earlier law and not 17A. That's the argument. Then, my lord, he relies on a judgment, my lord, of Kerala, where the court has held this, and it came to your lordship's court, my lord, in a bench of Justice Khanna and Justice Trivedi, my lord, dismissed the SLP and said, which I'll show to your lordship. Now let's leave it here. Now, my lord, your lordship may see on this question at page 30. Yeah, 33. Yes. 33. Below last 6-7 lines. I'm only on this part, I'm not reading anything else. It is pertinent to mention. My lords have it. In fact, my lord, if your lordship sees para 16, I will read from 4 lines from the top of that 16. There is no duty cast upon the authorities to obtain sanction to prosecute an employee not in service for prosecution of the offences also, which were committed before coming into force of 2018. It is pertinent to mention that in case in hand, a regular inquiry was ordered, kindly mark this one, on 5th of June with regard to allegations of corruption against the officials also by the DG, by referring to a letter of CBI number so and so, dated so and so, which is much prior to the insertion. So it started with CBI. So one letter is of 17, my lord, and 2 letters are of May, June 2018. So 3 letters, my lord, which are there, which show that this has started. Somebody said this is the allegation, start, so it started. So 17 and 2 letters of 18. That, my lord, is the discussion by the learned judge. Then your lordship sees para 17, page 35, para 17. So the judge, my lord, says, viewed from any angle, 17A will not be applicable in cases which occurred before so and so. 17A will be attracted so and so. The special judge will have season by both. That is clear. That's section 14. Lordship says I can read it. And this is very quickly, Lord. Yes. Next question will be, assuming PCI goes out, then what happens? I'm not saying it should go, but I'm telling you if it is not assumed. First question, if there is an amalgam method of PC and IPC, what happens? Answer is in 4.3. Your 4.3 will tell you also cases tribal by special judge and it starts with non-obstante clause. See clause 3. 4.1 is non-obstante. And 3. When trying any case, a special judge may also try an offence other than offence under 3, with which the accused may under the CPC be charged in the same crime. So he has the power to do for both. The idea you can't have 2 trials for the same bundle of facts resulting in different offences. So you give the power not to one. But another similar provision.
Mr. Gandhi, what they are trying to say is that if PC Act goes, 17A,
then what happens? I'll answer it.
So
That's the second question.
then 4.3 also would not be applicable.
No, but the law is, yes, you're right, is the argument. This court has held not once but several times. And if PCI goes beyond an amalgam of this and this, the special judge will still retain jurisdiction to try all non-PC. It is settled now. It's nothing new. Because see what happened, it will go back and forth. Therefore, my lord, 4.3 was amalgam in the beginning, and once the amalgam is made, it will go only on that track. And the case is dropped, or that is dropped, the jurisdiction, the special court will remain and should not judgment straight away. There are other public servants also. There are all kinds of things. If you keep doing this, then what happens? It's not only one person. When you spend a time or 10 days, therefore, what the law is, with respect, I submit. And if PCI goes, then non-PC will also be tried by the special court to be settled. Because otherwise, it will create havoc. If you have several people, it goes for one, doesn't go for one, what will happen? So there are 10 officers. There is not 17 for one, there is none for another, something. It will keep going this way. So it cannot be.
So the question would be section 17A would be offense specific or person specific.
So 17A, Lord, I will answer it. We'll come to 17A in a second. I'm just giving Lord, this is the rationale of 4.3. And a somewhat similar provision is in section 44 of the PMLA. What is that provision, Lord? There is a CBI trial because of predicate offense. There is a PMLA trial. Now, if both of them go separately, Lord, it may lead to conflicting results. Bundle of facts are same. Bundle of facts are essentially same. So, law said, Lord, that the CBI trial will be taken over by the PMLA judge. It will not, Lord, he will not mix it, but he will do it side by side. Because the same judge must decide two different offences sent to the same bundle. That's 44, just to show to you. Now, we'll go to the second question. What happens if PC goes and only IPC remains? Your Lordship may note there is a direct judgment law which is in our compilation. There are others, but I am showing you the latest. Lord,
Yes.
yes, Lord, there is this compilation. Lord, your Lordship may mark, give a copy to the other side. Your Lordship may mark, Lord, second page of the index, item 17, A. Srinivas Reddy. The paras mentioned here are not enough, Lord.
Where are you?
Lord, see page 2 of the index. Page 2 of the index. Judgment number 17. Your Lordship will get A. Srinivas Reddy.
Yes.
This is that judgment, Lord, of PC and non-PC. Your Lordship may write on the side. Lord, kindly add some paragraphs which are not mentioned here. Only conclusions are mentioned. Your Lordship may note paragraphs 15, 17, 38, 53, 56, 57, and 60. Now, my Lord, let's go straight to this judgment. Very quickly, I'll show to your Lordship. We get this out of the way. Turn to page 243 of this compilation, my Lord. Turn straight to para 15, my Lord, at 245. The special court at Hyderabad, by its order dated so and so, discharged the appellant from the prosecution under the PC Act.
Where are you reading?
Para 15, my Lord, towards the bottom of 245, my Lord. The special court at Hyderabad, by order of so and so, discharged the appellant from the prosecution under the PC Act for want of sanction. The special court, however, declined to discharge the appellant for offences under IPC. The special judge relied on this. Now, my Lord, your Lordship may turn straight to para 17 and then 38. 17. Feeling aggrieved with the aforesaid, the appellant went to the High Court by filing a petition